Welcome back to the Friday 5 for July 7th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota, and New York City. And let's take 5 minutes and look at 5 quick questions from the past week, things that come up in consultations and other questions that clients may have that you may also have questions about. Question number 1 this week, can I use a trust to hold my business ownership interest? And the simple answer to this is yes. You need to look at your local state laws, but in most states you are able to take a business interest and have your interest owned by a trust that you create. Now, clients will often ask, why is this a good idea? And the simple answer is it makes your interest in that business inheritable upon your death without having to go through probate court. So as an asset in a trust, it doesn't have to be dealt with in the probate court. They don't have to sort out ownership interest and distribute it. You can have a plan put in the trust for what happens to your business interests. Question number 2 this week, if I have to pay someone to fix a breach of contract, who pays for that? So in this case, a prospective client had called my office. They had hired a painter who had painted half of the house, but not the other half of the house. And they kept saying they would come back, and they would paint it. And then finally, they never did. And now almost a year later, she's got a 2-colored house. She's not happy with the results. So she had paid the initial painter $4,000. She had to find a new painter to fix the work and do it correctly. The new painter charged $6,000. And the question was, if she's going to bring a lawsuit, does she sue the original painting company for the $4,000 or for the $6,000? The simple answer is, in a situation like that, you should sue for the $6,000, which is the cost to repair. So you were always planning on spending the $4,000 for a proper paint job. In this case, you had to spend $6,000 for the proper paint job, which also fixed the prior paint job. So this also shows why it's a good idea to speak to a lawyer before you just bring a breach of contract lawsuit. In this case, it was going to be in our conciliation court here in Minnesota, but we had a good consultation about some next steps to take and whether you should sue for the $4,000 or the $6,000. Question number 3 this week, what happens if it takes too long to sign my estate plan documents? So when I'm working with an estate planning client, we have different time limits that we work under. So some clients will come in on a Monday morning and be ready to sign by Wednesday or Thursday. Others will take a little bit longer. These days, the average is about 4 to 6 weeks from when a client starts working on their estate plan to when we finally get the document signed. Now, some of my clients are actually years in the making. So this particular client I hadn't heard from in over a year. We had drafted documents back in 2022, and they just sat on the documents. They reviewed them and just never got around to coming in to sign them. So their concern was, are these documents still good, or do we have to start fresh and do all new drafts? The simple answer is you don't have to start new. You don't have to start fresh. You can use those documents you drafted a year ago. We want to check them to see if there's been any changes. So for example, if you've had another child, if you bought a different house, maybe somebody in the family has died, or you want to change around personal representatives or trustees or guardians, then we want to make those changes before we sign those older documents. But just because it takes you about a year to get through your documents and be ready to sign does not mean that they're not good and valid documents anymore once you sign them. We just need to do a few updates to make sure that everything is current. Question 4 this week, how do I leave my pets to a shelter in my will? This was actually the same client. We were discussing what we want to do with a plan for the pets. And in this case, the client had thought about the idea of using a pet trust, and they may still actually change their documents to include a pet trust. But one of their options was, if the family member that they were going to designate could not take their pets, maybe they would give the pets to the shelter. And you can do that. And you absolutely can reach out to your local shelter and say, we're interested in this kind of provision in our estate plan. What you need to know, though, is each shelter treats it differently. And some shelters will say, if you're going to do that, we then also need you to leave a bequest for their care. Let's say $10,000, $20,000, $50,000. I know there's a shelter in Texas that was like $125,000 for a dog or a cat. The reason is, if you want to leave your pet to that shelter with a provision that they will not be adopted, then that shelter is going to have to pay the costs for your beloved pet to live out the rest of their life at that shelter. So most shelters in that case are going to want some kind of a donation. However, in this case, the clients actually just want to have the cats sent to the shelter and then adopted from there. In that case, the shelter may not want as much money up front because the prospect of the cats being adopted is much higher and they're not being restricted from being able to adopt them. Question number 5 this week, if both of my parents die within a few months of each other, how do I sort out which will controls? Simple answer is whoever dies first, You look at their will and distribute the assets under that will. And then we look to the second will and see what happens under that will for the remaining assets. So in this case, mom died first. Mom's will said everything goes to dad. So that will gets used first to move everything into dad's name. And then when dad dies, we distribute everything under dad's will. Now, the reason you may want to consult with an attorney is when mom died, we need to determine whether or not we need to open an estate. If everything went to dad and everything was in joint names, there may not even be a need to open a probate with your local court. But that's a good question for your local attorney to make sure you know what you're doing and what estate has to be probated in that situation. So that's 5 questions in about 5 minutes. I think I went a little bit long this week. There's a link in the description. If you like this video, you can ask questions for future episodes. You can hit the like button, the thumbs up button, share it on social media. You can subscribe over on YouTube. Wherever you are, I hope you have a wonderful weekend, and we will see you next week.